Hello and welcome. I'm Jackie Stennett, a U.S. Army veteran and the Vice President of Academy Women. Thank you all for taking time to join us for today's event. Academy Women's Career Coaching Workshop, which is held as an annual event, will continue to extend its reach by bringing you a monthly webinar series. As with our annual career workshop, which will be held in 2025 on April 2nd as a hybrid event with options to attend in person or virtually, the monthly webinar series will provide insights from subject matter experts and thought leaders who share their knowledge on a broad array of topics designed to support the professional and personal development of military leaders. For those who are in or considering a career transition, be sure to visit our Virtual Engagement Center. The Virtual Engagement Center is a 24/7, always-on platform where members of the military community can gain access to important resources, register for upcoming events, and connect through asynchronous text, audio, and video chats with top-tier military-friendly organizations like First Command. And now, we are pleased to welcome First Command as our presenting partner for today's webinar. First Command first stood with Academy Women in support of our mission in 2019, providing trusted financial coaching and personalized planning that helps to keep our military members financially squared away. Thank you, First Command, for your unwavering commitment to the military community. Academy Women couldn't do the work we do without you. A special thanks goes out to Alan Bisenieks, a U.S. Army veteran who leads from the front at First Command to ensure military members are supported with the guidance, resources, and care they deserve as they navigate their unique challenges and work toward their financial goals. We'll also be joined today by legal experts Mike Hendricks and Laura Feltman from the law firm Johnson, Gasink, and Baxter. Mike is a U.S. Army veteran and a partner at the firm, and Laura is a U.S. Air Force veteran and attorney. Alan, Laura, and Mike, thanks to you all for making time to join us. You'll meet our team of experts shortly, but first, I'd like to introduce Susan Phelan, who will be your host today. Susan is a U.S. Air Force veteran, a graduate of the U.S. Air Force Academy, and is the founder and president of Academy Women. We've got a lot to cover today, so let's get started. Please join me in welcoming Susan to the virtual stage. Enjoy the discussion, everyone. I hope today's event will be helpful to you as you navigate your next steps. Susan, over to you.
Thanks, Jackie. It sure is a pleasure to be here today. So as Jackie said, Alan Bisenieks will be kind of hosting and kicking things off for us today. He is an Army veteran and a financial advisor at First Command. Laura Feltman is an Air Force veteran and attorney at Johnson, Gasink, and Baxter. And then we have Mike Hendricks, who is a partner and attorney at Johnson, Gasink, and Baxter. So without further ado, I'm going to kick it over to Alan and let you take it from here. Thanks, Alan.
Thanks, Susan, and thanks a lot for having us on today as part of this important event. As a financial advisor, there are 5 things when we're looking at plans for our folks. There are 5 important things, whether you're transitioning from employment to employment, whether you're transitioning out of the military, whether you're transitioning from full employment to retirement. You may be at various stages of where you're planning these 5 things, but they are important regardless. And those 5 things are a tax-wise distribution of income in retirement, a survivor plan, a long-term care plan, a liability plan, and the 5th thing that we do is an estate plan, right? To make sure that beneficiary/estate planning is done as part of your financial plan. And so we are fortunate today to have Laura and Mike on that are part of the professional organization that I use here as my professional team outside of my financial planning team here. And that's to help me in the estate planning for my clients. Mike and Laura, as part of JGB, have been fantastic for us for many years. They have supported our military clients in making sure that their estate is distributed in accordance with their will after they pass. And I know throughout the United States there are various laws that are there that apply to estate planning in addition to the federal laws that are also there. So I think Mike and Laura is going to provide you today some overview on estate planning. But again, we can be available for those specific circumstances for some of you or for you if that's something that you'd like in the future. So without further ado, I want to make sure I get it over to Laura and Mike to get going on today's topic. Thanks a lot.
So what we're going to do is we'll basically run through estate planning 101. We've already been introduced. I'm Mike, joined by Laura. This is us, JGB. We're centered in Virginia, all over the Commonwealth. We also service folks in Maryland, DC area, and the North Carolina. That's me. Graduated in 2003, West Point guy. Commissioned as air defense artillery officer, served 9 years, and then went to William & Mary for law school. Laura?
Hi, I'm Laura Feltman. I started out at George Washington University in Washington, D.C., and got my commission through the ROTC program at Howard University across the city. Then when I went into the Air Force, I started out on AWACS, the Airborne Warning and Control System, as an air battle manager. Then I went through law school, courtesy of the Air Force, and became a JAG and was JAG for a little over 12 years until I retired. And now I'm here at JGB. Next slide. Today, what we're going to cover is what is estate planning. We're going to discuss some of the different types of estate plans and key estate planning documents. We're also going to discuss some special considerations for military families, and then we'll field some questions. Next slide. So what is estate planning? Well, first we have to talk about what is an estate. Basically, an estate is all the stuff that you've accumulated throughout your life that you own. Objects, bank accounts, investments, stocks, bonds, businesses, copyrights, trademarks, all those things, those are your estate. And the purpose of and goal of an estate plan is to ensure your stuff gets to the right people at the right time while minimizing the transfer costs, and also to have a plan and make it easier for people to take care of you in times of incapacity. What do we mean by incapacity? Well, a person is incapacitated if they are unable to manage their property, their financial affairs, or their physical health, and they need somebody else to do it for them. Sometimes people are permanently incapacitated, but oftentimes we're all incapacitated at one time or another for a short period of time. Next slide. So there are different types of estate plans, ranging from one end of the spectrum, which would be no plan at all, to the other end, which is best, having either a will-based plan or a trust-based plan. And in between, there's an option of some people use joint ownership with right of survivorship to transfer property. Others use beneficiary designations only. And then gifting is another strategy for transferring property. Next slide. No planning. The big advantage is it doesn't cost you anything. It's no time, no money. However, there are a lot of downsides to it. You end up with probate and administrative costs. What you're essentially doing is you're letting the state make the plan for you. Each state has its own laws that dictate what happens when somebody dies without a will or a plan. And when somebody dies without a will, that's referred to as dying intestate. And so the rules of intestacy, for example, in Virginia would be that if somebody dies who's unmarried but has children, the children would split everything. If they were married but no children, the spouse would get everything. Makes sense. If they're married and have children, then it gets a little more complicated. In Virginia, if the children are from the same relationship of the husband and wife, then the spouse still gets everything. But if they are from another relationship, or one of the children was not adopted by both parents, then the spouse gets 1/3 of the estate and the children split the other 2/3. And there are other rules that go down for people who are not married and have no children, but you get the point that you're letting the state dictate who gets your money and your assets, and it may not be who you want, because a soon-to-be ex-spouse is still a spouse under Virginia law. So another thing that makes having no plan a bad idea is that you end up with a lot of court involvement. such as needing to get a guardianship or a conservatorship in cases of incapacity. I mentioned what incapacity is prior. Incapacity also means that you could be minors count as incapacitated because they can't sign contracts. So if an heir is a minor or otherwise incapacitated, then the state again gets involved, have to go to court, file a pleading, and show that the person's incapacitated, and then designate somebody who's appropriate to manage their affairs. Oftentimes the word guardianship is used to refer to the person who's going to be taking care of the person's health and their body, versus conservatorship, which is often used to refer to taking care of their assets and their possessions. A lot of times they're also used interchangeably, depending on the state. So like I said, you end up with lack of control throughout the process, and it's expensive and stressful. You can also end up with disrupted access to survivor benefits because you need to go to court and determine what should be done. You also end up with unintentional beneficiary issues. What do I mean by that? Well, again, like I said, you may end up leaving something to a soon-to-be ex that you didn't intend, or leaving out a foster child or a stepchild whom you love as much as your biological children, but because they're not adopted under Virginia law, they wouldn't inherit anything. And then you also end up with long-term care concerns about who's going to manage your assets while you're alive if you need to have somebody designated. Next slide. Joint ownership, that's better. A lot of times husband and wives have joint ownership with right of survivorship. And so that makes it really simple. You can do it with somebody who's not your spouse too. It means that when one of you dies, the other one gets the whole thing as well. All they have to do is provide the death certificate and they own it all together. And it can possibly avoid probate. On the negative side is that sometimes it doesn't. Oftentimes when the second person dies, they do not have an estate plan either. And so we end up back with the same route of having to go to court and doing probate and following the state's plan. It's also not flexible because when somebody's an owner, you can't take them off of the deed or off of the account without their permission. So they are equal owners and there's nothing you can do about it if circumstances change. The unintentional disinheritance, it's similar to with no plan. If you put somebody on an account, sometimes some parents want to put the oldest or the most responsible child on the account, and with the understanding that that person will divvy out the money to the rest of their siblings. That doesn't always happen. Also, when somebody is a co-owner of an account or land, their liabilities can affect your property because their creditors can go after their assets and their assets are shared with you. So you could end up having to sell your home because somebody got into a car accident and was sued. And if that person is a joint owner of the property with you, there's nothing you can do. And then tax implications. What I mean by that is when somebody dies, there's some tax advantages to inheriting property regarding capital gains. And you may not get that if you're already an owner. You'll get only minimal tax advantage, if at all. Next slide. Beneficiary designations. That's very effective and simple. You just use a company's form, a bank's form, to designate who gets it when you're dead. Or your life insurance policy. With stocks, it's referred to a transfer on death designation. With bank accounts, it's often referred to as a payable on death designation. A lot of times you can do this online. So when when you pass, the company knows where it goes. And that too, possibly avoid probate. But again, when the second person passes away, or if that person is predeceased you and there is no contingent beneficiary, then you could end up again back in the court with the whole probate proceedings. Another negative could be if the person who's going to be taking as a beneficiary is a minor or incapacitated or incompetent. We end up back in the guardianship, conservatorship position where you have to go to court, have the hearing. So again, expensive, time consuming, and stressful. And then there's lack of protection with commingling assets. There are different estate planning tools that can help separate assets from marital assets or protect it from suits against a spouse. And this won't do it. These are some considerations with beneficiary designations. One example would be that I had a client who did have a will, but she was using beneficiary designations to try and avoid having to use the will to have it probated. Yet in the will, she had expressed a desire and expressed it shortly before her death about her concern about her children spending too much, that they really needed to have somebody overlooking it. And in her will, she had designated her sister to oversee it. But she listed the children as the beneficiaries, so that instead of it, she thought it would flow to the kids through the will, it just wouldn't have to be probated. And that's not how it works. If you have a beneficiary designations, that's how it goes. And so the kids got the money straight out, and there was nothing left for the sister to do to help with. And there was no money for her to pay her sister's bills either, because it all went to the children. Next slide. Gifting. That's another way of making sure that your loved ones and charities get the money that you want or the property that you want. And one of the advantages is that now you can give $14 million almost without having to incur a gift tax. Most of us don't come anywhere close to that, but you can give and it won't, you don't have to worry about that. But you lose control. And in today's world, especially with medical costs, you don't know what you're going to need in the future. And once you give it away, it's no longer yours. The other thing is that, people may not keep their promises. Sometimes somebody will arrange to give property to a relative with the understanding that they'll be taken care of. That doesn't always happen, and you can't get that money back. There are Medicaid implications. If you give too much money to somebody on Medicaid, it could kick them out of the program, or vice versa. If you give money away in order to get on Medicaid, you have to know that there's a look back provision. And so you may be giving away your property for no reason because you still may not be able to get on Medicaid. And again, there are tax implications regarding when you inherit something versus when you're gifted it. Capital gains taxes are involved. Next slide. Mike, I'm going to turn this over to you. You need to unmute.
Thanks, Laura. So I'm going to talk about wills, right? Wills are great. Thought of control, very simple documents. As far as control, they're very good about getting the things that are in the name of the testator, testatrix, the person who's writing the will, to the beneficiaries, right? They're simple documents. We're talking typically 7 to 10 pages. And the reason they're able to be simple is because they're really just a skeleton, right? There's a skeleton of your plan, and then the flesh is put on by the state code, right? But because of that, they're not really portable, right? And so if you take, say, a Virginia will, you go down to Florida, it might not be as efficient or as effective. You take a Virginia will, you go up to New York, not going to be as efficient or as effective. Now, folks who are active duty, there are some federal laws that allow you to draft a document with legal assistance, and you can take that around. But, once you transition, once you're out, those no longer apply to you. This can cause some real issues too, right? So kind of like Laura was talking about, if the will plan, the goals and objectives of the will deviate from what the intestate laws are, right? So you have a situation where, you're given to church, you're given to charity, those aren't intestate beneficiaries, right? It's just family. So if you have a will, we'll pick on Georgia for a little bit because they let 14-year-olds witness a will, right? So if you go to Georgia and you have 2 14-year-olds witness a will, and you come up with Virginia to probate it, you don't have a will, right? Now say that you were leaving something for, your cousin in that will, and you're leaving something for the church, and you're leaving something for your alma mater, and then your will gets thrown out in Virginia. All those beneficiaries that you had designated in your will get thrown out, and you're left to the intestate proceeding, okay? Wills are also definitely documents, okay? And that's kind of important, right? Because as people, as medicine changes, they're living longer and longer, the likelihood of incapacity is increasing, okay? So I had a situation once where an individual came in, mother was just diagnosed with Alzheimer's. He was trying to do the right thing. He came in with that, he's waving the will in. He's like, hey, look, my mom got diagnosed with Alzheimer's, and I want to sell her house so I can pay for her care. And I said, okay, so what do you got? And he's like, I got the will. I said, okay, you got the will. Do you have any other documents? And he's like, I'm the executive. I said, I hear you, I understand. Do you have any other documents? Power of attorney? Is there a trust instrument? Is there anything? And he didn't have anything else. And since wills are death-only documents, he doesn't have the power to sell that house until such point that she passes away. So while she was still alive, he had no power under the will. So what we ended up having to do is we had to refer him out to get a conservatorship. And then, 18 months later and a couple $1,000s, he was able to then sell that house. Okay. Lack of portability, we kind of discussed a little bit, right? The wills are very formal documents. Each state has formal construction requirements. How many witnesses need to sign? Where they need to sign? Do those witnesses need to be notarized? What kind of statements for the notary are required? If you violate any of those construction requirements, your will be thrown out. You'll have to proceed in testing. They're public documents, okay? Public documents, they're out in the open. Once the deed is recorded, either in the clerk court or at the courthouse, depending on your state, it is a publicly inspectable document. Some folks don't care, right? Some folks don't care that the world knows who their favorite child is. Some folks do. Also, we've been seeing this a little bit more and a little bit more and a little bit more, but there are some unscrupulous folks who they look at the obits and then they go to the courthouse and they pull the deeds. And if there's a probate, some of the great grandmas, she's got a new, somebody told she's got a new roof. Somebody's repairing her basement. There are some folks who will prey on individuals, and we're just giving them additional information to be able to do that. So we just got to be a little bit circumspect about that. Also, probate. You've seen kind of probate throughout the presentation. Each state is different, but each state has a probate process. Okay. When we're talking about the probate process, literally what we're talking about is this piece of paper that I hold in my hand, Mike Hendricks' last will and testament. Okay. But when we talk about it colloquially, what we're really talking about is the will taking the assets from the name of the beneficiary the name of the decedent, the person who passed away, to the name of the beneficiary. That entire process. And that entire process, it varies from state to state, but each state has one, and there's going to be a referee for that. That's going to call, mix my metaphors, and I'm calling balls and strikes, right? So in Virginia, just by way of example, we're going to go through the probate process. Okay, beginning the process starts with putting to will's record. I would strongly encourage you to talk to somebody that does this before you go to the court. Okay. Folks mean well, but sometimes they're undertrained, right? You go to the bank, grandma passed away, and she's got $10,000 sitting in a bank account. You're the beneficiary. You're like, I want to access this. They say, hey, you got to go to court. You got to get your letters of qualification. You're like, okay, and you go to court and get your letters of qualification. Well, if you get your letters of qualification, once you qualify, you're stuck in the entire process. I quote at least 2 years, right? In Virginia, at least. Your mileage may vary from state to state. But in all states, once you begin that process, once you sign on the dotted line, once you swear that you're going to do everything that you're supposed to do, you can't extricate yourself from that process. You can't come out of it. Okay. All states have a small estate statute where there's a de minimis amount of assets under which you don't have to go through a full-blown court proceeding. Okay. In Virginia, we have a two-step process. We have a small estate affidavit for $50,000 and below, right? Then if it's $25,000 and below, it's a small state affidavit because our General Assembly folks are really creative. But the small state affidavit is just a signature in front of a notary. You sign the small state affidavit in front of the notary, you're good. You can pick up any asset less than 25 grand. It takes minutes, right? If you have between $25,000 and $50,000, you're gonna have to go to court if there's a will to drop the will off, but you don't qualify, you're not stuck in this entire process. But again, if you go to pick up that 10 grand and you go to the court because the teller or the individual you spoke to told you need a letter of qualification, you're going to be stuck in this process. It is time consuming. It is expensive. It's stressful. You're going to be taken off work. You're going to be paying a lot of bills, right? So we want to avoid this if at all possible. Okay, so you begin the process. Another thing, the qualification in Virginia definitely, and typically in other jurisdictions, starts a clock. There is no, hey, you have to qualify within X amount of dates when somebody passes away, right? But once you qualify, that starts a clock, okay? And when that clock starts, you yourself, you're a fiduciary, you are personally responsible for executing this thing. If you fail to execute, you can be sanctioned. Those sanctions are yours. You've got to pay them. If you qualify and then you don't do what you say, they're going to call you on the carpet. You're going to go ahead and they're going to have a show cause hearing. You're going to have to tell the judge why you're not doing what you're supposed to be doing. And if you continue to not doing it, you'll be held in contempt of court. So it is very serious. Okay. So once you qualify, 30 days, you got to provide notice. So you got to tell everybody that who is either an heir at law or an heir under the document, so listed in the will, that the probate is beginning. Hey, Mike's passed away. Tell his kids. You tell anybody listed in the will. You got to notify the commissioner of accounts with an affidavit under the penalty of perjury. Now, in Virginia and West Virginia, we have a commissioner of accounts. That individual is an attorney appointed by a judge that, like I said, supervises this process. In other jurisdictions, you're actually going to appear before a judge. Okay, and that judge is going to kind of, make sure you're doing what you're supposed to be doing. The inventory is the gathering everything up, determining a date of death valuation, then reporting this to the court. In Virginia, the commissioner of accounts gets paid off of the amount moving through the probate process, so they're sticklers for it, right? And I'm not saying this because they get paid off of what's moving through probate, but they do, right? And so you'll hand this in, oh, grandma had a car and she had a house. You hand it in like, oh, grandma didn't have clothes. Oh, it comes back, you got to clothes. Oh, she didn't have furniture, come back furniture. You got to make sure that you do a full faith, best effort when you're reporting this stuff. That's due 4 months after the date of qualification. Then you get the accounting. The accounting is balancing a checkbook, money in, money out, distributions and disbursements. Lawyers like to be difficult and make things, with our words, right? So distributions are money to people, disbursements are paying bills. You pay everything, all final debts and expenses. The accounting period is 12 months, covers, but it has to be filed 16 months after the date of qualification. So the reason I quote at least 2 years is because you file taxes. Tax return comes in month 13. Once you pass that 12-month period, you're stuck in another 12-month period, right? Grandpa was a rugged individual. He lived on his own until he passed away. Hearing went, there's a leak behind the wall. You're going in there to go take care of the property. Turns out you got to repair the cabinets. You got to do the floor. You got to find a contractor. It takes time, right? Then it stretches out. You're stuck in a two-year period. But you do a great job. Money's out. You've balanced everything to the penny. And then you prove that you've paid all final debts and expenses, and you filed the taxes, and then you're done. Okay. Each state has an analogous procedure. Fees, right? So executor fees. Lawyers are bad at math. If we were good at math, we'd be doctors, but here we are, right? And so we're going to use $1 million estate. Each state has a different, and it's going to be marginal, like your tax rate, a rate of compensation for the executor. Folks appoint their kids and they're like, oh, little Johnny's not going to take executor fees. He's just going to give the money to his 3 other siblings and he's not going to take fees. Then he's taking off work. Now he's living in Ohio and he's got to come to Virginia. Eventually he's like, wait a second, this is real work. And then they take the fees. So we have seen, more and more individual executors who are also beneficiaries taking fees. But on just $1 million, it's 41 grand for just executor fees. That's exclusive of the any sort of probate tax that's assessed. That's exclusive of any court costs. That's exclusive of anything that you have to pay the commissioner or counsel to the judge. Okay. And then we go to revocable living trusts. Okay. Greatest control. Functionally, trusts are contracts. Okay. And because they're contracts, we can put pretty much whatever we want. Okay. They really do allow us to control things. In my situation, right, I got an 8-year-old. She loves her daddy for now, right? We'll see what happens in the future. But if something happens to my spouse and I, from 0 to 25, my brother's in charge. Right? From 25 to 35, it's a co-trusted relationship. 2 keys. They both have to agree before any money's getting spent. Right? She's like, oh, I want a Maserati. My brother's like, oh, you can walk to it. They go back and forth, and she gets a Honda. Right? So you have that kind of control in a trust. And at 35, she gets the keys and she can do what she needs. She can buy a Maserati, right? But since it's revocable, you can continue to make changes so long as you have capacity, right? So if she turns out to be a knucklehead, you can push that to 35, 45, 55, or whatever. Whereas if we're in the will process, it's 18, right? You're pegged to 18. That has its own set of issues. But another thing with the revocable living trust that's very good and worthy of thought is it contemplates incapacity. What do I mean by that? If you think of the trust as a bucket, you put your assets in the bucket, right? That process is called funding. Once you have those assets in the bucket, the trust is funded. There's a key associated with that controlled by the trustee, right? They control that. If you become incapacitated, that trustee can use those keys to manage those assets inside the trust for your benefit. Okay. So if we go back to our early example, that gentleman that came into the office was like, hey, mom's incapacitated, I've got a will. Sorry, go to get your conservatorship 18 months later, a couple grand later, if you can do it. We're talking, a couple days to create a new certification of trust for your incapacity trustee, and then they have the ability to sell that house. Okay, so it's much more reactive. You're in a much better position with a trust vis-a-vis incapacity. Protected portable and private declarations. So protected. If you remember what I was talking about, there are ways of transferring assets to your beneficiaries that you can protect them from certain liabilities. The trust is the way to do that. You can pass your assets to your beneficiaries in a trust share. If you pass them in a trust share, it's presumptively a non-marital asset, right? It's a separate EIN, it's not under their social. And because of that, it's presumptively a non-marital asset. Additionally, if that individual is receiving means tested benefits like Medicaid, we can take that general needs trust, flip it to a special needs trust. And anything contained in that special needs trust is not an available asset for the computation for Medicaid, right? And because of it, you can leave them $1 million, but they can still be on Medicaid, and there's no look back period. So there's significant benefit there. And they're private, right? So they are contractual obligations. They don't get recorded. You may hear folks say, hey, I recorded my revocable living will with the court, which you can pretty much record anything you want at the court. I would strongly dissuade you from doing so, right? They're revocable. You decide in 2025, X and Y are getting a share of your assets. And then, in 2035, you want A, B, and C to get your assets. If you record a trust saying X and Y, are you going to record your new trust? Are you going to remember to record your new trust? Is X and Y, you're also giving X and Y evidence to maybe contest the ABC trust, right? So you don't want to record these things. You want to take advantage of the privacy. They're also portable, right? So portability, since they're contracts, full faith and credit clause of the United States Constitution says if it's valid in one jurisdiction, it's valid, well, one state is valid in all states. So there'll be a choice if your document's well drafted, there will be a choice of law clause there. So if you have a Virginia document and you move to Florida, it's still a Virginia document. You can reach out to your Virginia attorneys. If you have, a document in Wyoming for Wyoming situs, it's law talk for where we choose it to be headquartered. So your Wyoming document with Wyoming situs, and you move to New Jersey, it's still good. So it's a very good document to have. If you're moving, say PCS every couple of years, right? That you don't have to relook. You don't necessarily have to relook your documents every PCS, right? Back end expense. We were talking about the executor fees being 41 grand on $1 million. If you paid a professional trustee to execute, you're probably talking about 1% of total assets. So you're 10 grand on the trust, you're 41 grand on the deployment, right? But it's not all smiles and sunshine, right? Upfront expense, much more complicated. 7 to 10 pages for a will. We're talking 100 pages plus for a trust. It's going to be more expensive. It's going to be more expensive upfront, but they're both good plans, right? If you take away anything from this, is that if you want something to happen, you got to write it down. Will, trust, right? Now, when I say write it down, it's not a composition notebook like if something happens, pull it up, composition notebook. It's not that I love me book that's in on the bookshelf, right? You want to make sure that there are legally sufficient documents that you write this stuff down. Other complexity, like I said, 100 pages plus, lots of branches and sequels that we kind of go through in the trust to try and cover for every possible thing that happens. So it results in a very complex document, and then it requires funding. If your trust plan fails, it's probably because it wasn't funded correctly. Lawyers like to be difficult. Like I said, we call it funding. It makes you think that you have to pay the trust something, but funding really is only changing either the ownership or the beneficiary designations of your assets to coordinate them with the trust. Okay. If you have a partner in line first command, they can do that stuff for you too. So that kind of helps. Okay. Ancillary documents, right? So trust plan, will plan. This is the plan part of the plan, right? Advanced medical records, very important. We're talking about healthcare power of attorneys, HIPAA releases, and living wills. Healthcare power of attorney, who can act? If you are unable to make your own healthcare decisions, who's going to make those for you? In cases of incapacity, or maybe it's just a temporary incapacity. Maybe you go in for surgery. You want to have somebody identified to look after you for that during that period. Now, each state has their individual kind of default statutes, right? But the issue you run into, one, that may not be the person you want, right? Your spouse predeceases you, you have a child that you are, estranged from, and you want your buddy to make your healthcare decisions, right? The statutes usually go by blood, right? It goes spouse and then blood quantum, right? And so in that case, you want your buddy who is not in the chain of command to make the decisions in the default. You've got to write it down. You've got to name them, okay? The other thing folks tend to worry about here is that, somebody's going to do something that I don't want to happen. Well, you're the principal, and the power comes from the principal to the agent. And so nobody can overrule it, right? As long as you're able to communicate, you're still in charge. However, you get to the point where you can't, that's when this comes in. Then you got your HIPAA release. HIPAA release is, you have a statutory, HIPAA gives you a statutory protection of your medical information, and you have to waive it affirmatively, right? So if you want somebody to be able to call the doctor and see about you, or like, hey, when is my appointment? You have to have one in your HIPAA release. Sometimes there is a difference between who you have on your HIPAA release and your healthcare power of attorney. HIPAA release is sometimes more expansive, right? Maybe you want your spouse and then your oldest child making your healthcare decisions, but you want your other 3 kids to be able to call in and find out about you. So maybe they're on the HIPAA release, but they're not on the healthcare power of attorney. Then you get your general durable power of attorney. General, that it's everything; durable, that it lasts into incapacity. This is different from your deployment powers of attorney, which are typically special, limited in scope and duration. Okay. General, it's everything. Durable, it lasts in incapacity. Okay, that's important. If you have just the will, this is what folks are going to use to be able to manage your financial assets. If you have a trust, the non-trust assets or assets that are going to be transferred to the trust on passing will also be managed by the agent of the power of attorney. And you got a pour over will. A pour over will is kind of like very much a break glass in case of emergency document. It works in conjunction with a trust. You have the bucket here, and there you pass away and there's a piece of property that's not in your name, that's only in your name and not in the trust when you pass away. Great uncle and you passed away and left you a house, right? So the house is outside the trust. The pour over will, the only beneficiary of the pour over will is the trust. It allows us to probate that house, dump it into the trust so it moves per the terms of the trust that you decided. And in college planning, that's just that's fancy lawyer talk for adult children, right? 18 years old, they're still living at home, hey, pick up your boxers, but in the eyes of the law, there's adults, right? And so if they're in the hospital, they're not going to disclose any information to you. You can't make decisions for them. What we're talking about here is adult children at a minimum should have the healthcare power of attorney, the HIPAA, the living will, and the power of attorney. Okay, the general will power of attorney at a bare minimum. Hey, they're going off to college. Hey, they're going off to basic. Hey, they're graduating high school. You need to kind of think about that. And then special considerations for military families, deployment planning. Critically important to not only review your documents when you get orders, review them, make sure that they say what you say, make sure that your next of kin can locate them where they're located, that they're in good order, that they say what you want them to say. But also look at your beneficiary designations every time you go, right? Every time you deploy, look at your beneficiary designations, like your SGI. Make sure you signed up for it. Make sure it has beneficiaries, right? It's a great benefit. You want to make sure that you use it and it goes to the person that you want it to go to. Laura was speaking to, the soon-to-be ex-spouse. There's been numerous times where the soon-to-be ex-spouse, the deployed part, the service member passes away. The soon-to-be ex-spouse gets the SGLI, and then the new partner, girlfriend, boyfriend asks, what can I do? And there is no, you can ask nicely, but aside from that, there's no legal recourse, right? Because the beneficiary designation is controlled. Prenuptial agreements, strongly encourage folks to look at a prenuptial agreement. I know lawyers are always the kind of like worst case scenario people, but you've got great benefits, right? You're going to retire. It'd be, we want you to get the full enjoyment of your benefits, right? Prenuptial agreements don't prevent you from giving. Doesn't say you love anybody any less. Doesn't prevent you from giving things to folks. It just sets the beginning, right? Hey, your stuff is your stuff. My stuff is my stuff. Anything, but it doesn't prevent you like, hey, I'd like to give you, I'd like to transfer this. I'd like to make you the beneficiary of this. You can still do that, but they can't force you to. So that's important. DD 214, lots of benefits. Key on to that. Death benefits, burial assistance, aid and direction, right? You want to make sure that your family members have access to that, know where your DD 214 is. So if something does happen to you, they can access those benefits. It's a lot easier for you to put that somewhere where they can find it now than fight in the National Archives for it, okay? And then special considerations, right? So we just want to talk a little bit about SBP, right? So it's kind of like a annuity provided for by the government, right? 55% of your retirement pays for max coverage, right? It's right. You got to talk to your financial advisor as far as, do you want to do SBP? You're doing other things, but if you do SBP, especially if you have a child with special needs, right? If you elect to give to a child for special needs, they will receive those benefits the entirety of their life, right? But like we spoke about earlier, if you give a child with special needs who is receiving needs-based benefits this money, you disqualify from benefits. So we create an irrevocable trust, okay? The irrevocable trust is kind of like the other trust we were talking about. It's you create a bucket that's in stone. You can't change the terms when you create it. So you write this, it's in stone. Before you're final out, you're going to put these assets, you're going to direct that survivor benefit pay into that trust, and you're going to have a list of folks, chain of command, who's going to manage those assets for that child with special needs. That is an irrevocable transaction. You're going to sign a bunch of stuff with personnel being like, I know this is irrevocable. I know. You really, really, really cannot change it. And then you put it into this irrevocable trust, and then they'll have those access to those benefits for the entirety of their life. Okay. What else do we got? Oh, questions. So we'll open it up for questions.
Thank you so much. I know I have a major to-do list after hearing your presentation, but let me share some questions from our audience. So one attendee asked, what state governs wills? And if you could speak a little bit to how they may be different. And then the second question tied to that is, where descendant is a resident and files state taxes, is that what would govern the state that you would have to have your will in?
Yeah. So domiciliary is what controls, right? And domicile is fancy lawyer talk of where you last lived with the intent to remain. Okay, so you're out, right? If you're in, you have your home of record, it'll be your home of record, right? But if you're out, it'll be where you're domiciled. So you retire, you settle in Arlington, you pass away in Arlington, you're going there, right? If you live in Arlington and you go to Disney World and you die at Disney World, you don't do it there, you do it at your domicile. Now, for beneficiaries, from a tax perspective, the state where that individual is domiciled and that they do the will, probate process, that will govern estate tax, right? That'll govern the probate tax. Now, as far as the beneficiary, your mileage may vary depending on the beneficiary and their minimum contacts with the other state, right? They're going back and forth as far as like trust planning and what is the de minimis contacts required before a state can tax a trust, because California wants to tax all the trust of all their beneficiaries, right? And so your mileage is going to vary on this, as far as the beneficiary is going to vary on the state. But as far as the person who's passed away, it's going to be the state where they were domiciled. The state of where they're domiciled is also going to dictate the construction requirements for their will or for their trust, right? Unless that trust says, hey, I want to be under Virginia law, or I want to be under Wisconsin law, right? But the wills, it's going to be where that will is going to be probated, right? And so, like I said earlier, right, you got Georgia, 14 of those witnesses a will. That's fine in Georgia. That doesn't play anywhere else. Okay.
I'd like to add something also, that a will may need to be probated in more than one state. If somebody owns property, real estate in another state than where they're domiciled, then they'll probably have to file the will in the second state as well, or third or fourth, however many states are involved.
That's important too, right? Especially for military members, right? You move, you got stationed at Fort Bliss, right? You buy your house out, buy your house in El Paso. Then you move here, you move over and now you're at Eustis and you buy a house in Williamsburg. Now, you pass away in Williamsburg. You do your will in James City County, right? And then, like Laura said, you gotta get your exemplified copy, and then you gotta go back to Texas and do El Paso County. So, yeah.
Okay, so we have another question here. Will SPOA and medical directive POA issued while a service member is on active duty still be valid when they leave the service? And if not, is there a time frame where those may expire or where they're no longer valid?
Yeah, so I will tell you, and I'll let Laura speak to this, but you will find that a lot of your powers of attorney that are drafted on post contain expirations, okay? And this is and what this is, the JAG officers that prepared it, they're bouncing around, they move and they retire, right? There's a tail liability that's associated with that. They want to cut that tail liability for that lawyer that prepared those documents. So you got to go to the individual document and look. There's been a couple of times where we've been surprised where we've had retiree spouses, spouses of retirees, retiree passed away, spouse becomes incapacitated. Kids are like, oh, we're in good shape. We got the power of attorney. And you look at it like, oh, it expires in 6 months, right? So you just want to be very circumspect with that. Additionally, just good housekeeping. You shouldn't be rolling around with powers of attorney, especially financial ones, that are really old because they get stale. And it's, whereas contract law is like, you must do this. The power of attorney is like, hey, can you please do this, right? And so Wells Fargo doesn't have to accept that. And they're probably not going to accept the 10-year-old power of attorney. So you do want to get those routinely looked at. Or?
That's exactly what I was going to say. The healthcare powers of attorney tend to last a lot longer and not be as problematic. But definitely the financial ones get stale and do have terminal dates, but you do need to check the specific document because each legal office had different policies on what they did.
Okay. We have a scenario here from Nichelle. She's in Georgia. She has 2 children and wants to create a trust for her home. Where should she start? Now she has a will.
Yeah. So when you have your trust, if you remember from before, we talked about horrible, right? So you're going to find a local practitioner that's going local estate planning practitioner. We're a little biased in that this is all we do. But you want somebody that like lives and breathes this stuff, right? You get somebody to create your trust. You'll get a pour over will associated with that. The pour over will cause the will that you currently have to be revoked, right? And so you'll put all of your trust. Once you have your trust, that's when you'll put your home in. That's when you'll put your other assets, because there are benefits to your beneficiaries by pushing that stuff through a trust. You want to make sure you coordinate all your assets with that, not just the home.
Okay. We have a question from Rachel. What if we buy property in a different country? Where would it be processed and would it change anything?
Yeah, so typically what we're talking here is domestic assets, right? So your CONUS assets. If you have OCONUS stuff, that's going to be governed by the jurisdiction where those assets are, okay? You also got to kind of be circumspect too, right? Because there are a lot of countries that have a citizenship requirement for the transfer of real estate, right? So you're going to have to consult an attorney or a barrister or whatever they call them, depending on the place you are, a legal practitioner in the jurisdiction where that property is held, how to transfer it. And then if your beneficiaries are even able to receive those from that property.
Okay. Question from Shauna. Could you speak to the differences and pros and cons between a revocable trust versus irrevocable trust?
Yeah. So irrevocable trusts are written in stone at the time you're writing. Okay. And so there typically we'll see these kind of in the context where we're talking about the survivor benefit pay, and we'll create one for that. Or if you have, say, a person who was injured in a vehicular accident where they can't make their own decisions, that you'll create an irrevocable trust so they can access Medicaid, and then the proceeds, well, not proceeds, but the money from the judgment gets poured into that trust, right? Or if you yourself are trying to qualify for Medicaid, you do an irrevocable trust, but like Laura said, there's a 5-year look back on it, right? So you want to make sure, that you consult a Medicaid practitioner before you do that stuff. The irrevocable trusts are typically used for specific purposes like that. There are also like tax planning ones where you want to get tax planning ones. You got irrevocable life insurance trusts. There's all kinds of different ones. Revocable living trusts are typically the capstone document for your estate, right? Who gets the stuff when I die? Who's going to take care of me when I'm incapacitated? It does become irrevocable when you pass, though, right? So it's revocable while you're alive, it becomes irrevocable when you pass.
Okay. Now, we have questions around costs for all of these and understanding that it probably varies around the country, but can you just give ballpark costs for setting up a trust, making sure doing all of the recommendations that you suggested for, say, an average person?
So, it varies, right? It varies by market. If you're in New York City, it's going to cost you more than it does if you are in Williamsburg, Virginia, right? So we're probably talking somewhere between 5 and 10 grand, right, for a trust plan. It's going to be less expensive for will plans, somewhere between $2,000 ish, right? But that's not just the will; that's all the stuff, right? You make sure you're getting all the stuff. Don't pay $2,000 for just the will. Make sure you're getting all those ancillary documents that we talked about. But I'm also very much like, don't pay the attorney if you don't have to. So if you have access to, if you're looking for a will and you have access to services on post, I will consult legal assistance first, and then I would go on and seek a private practitioner.
Okay, fantastic. If there are no other questions, then I will, oh, here we have another one. This is from Kathleen. Wills can be written up for retirees at a nearby DoD installation's JAG in most cases. And so would you recommend starting there and then following up afterwards?
Yeah, absolutely, right? Because again, don't pay the lawyer if you don't have to. So if JAG is going to do it for you, right, that's great. The thing with JAG, though, is they typically don't do the higher order. Right? So they'll give you will, do you power of attorney, right? Again, look at the power of attorney for the expiration date, but they're typically not going to do trust. They're definitely not going to do ILAs. They're definitely not going to do irrevocable trust, right? So I would absolutely start there. You earn those benefits. I would 100% avail myself with them. And then if you can't, then you can go ahead and look on the transition to a civilian practitioner.
Now, you said to keep the documents in a safe place. Would you recommend having an electronic version as well as a paper version? What would be a best practice for? What's that?
Okay. Yeah. So yeah, absolutely. So like our clients, when we do it, we send digital copies, right? Typically, if the document it'll say have language in there, this, facsimiles, digital reproductions are as valid as the original. That typically works for everything else except the will. Well, you got to have the original, right? So keep it somewhere safe. Doesn't need to be in a safety deposit box. I typically don't recommend those because the authority to get in the box is then inside the box, and then we got to go get a court order and this whole thing. It's a whole song and dance. So I typically avoid that, but like my stuff is in my bookshelf at home, right? And my trustees know where to put it, right? That's what you do. You can get a little firebox from Walmart, something where you store your valuables, but it doesn't have to be anything special.
Okay, great. And then we have a question from Bonnie. What do you have to do if you want to cancel your will?
Varies from state to state, right? So in Virginia, you can obliterate it, right? You can use it as kindling, shred it, right? And do whatever you want. Or you can create a new will that will revoke your previous will by operation. What about presumptions too, right? So like if you have a will in your possession, and we know you have a will, and then you pass away and you can't find it, the presumption is you revoked it, right? Because you can just line through it, you can shred it, you can destroy it, which is also why you don't record your wills or any other testamentary documents before you pass.
Fantastic. All right. Let me just say thank you so much. I learned a lot personally, and I think all of us did on this webinar. I feel like I need to go through the recording in slow motion and take notes, more and more notes along the way, because there's a big to-do list. The three of you were fantastic. We're so grateful, and we we'll definitely have more questions that come along, and we'll pass them your way. Right. So moving
Thanks.
forward, I would just like to say that we have resources, information, access to experts on our virtual engagement center, and we encourage you to take advantage of that. It is a free resource to all members and all participants in our programs, and you can join through that QR code or also through our website, and that is at militaryowls.org or academywomen.org. The upcoming programs, mark your calendar and register now. On the 2nd and 3rd of April in Arlington, Virginia, we will be hosting the Career Coaching Workshop and Officer Women Leadership Symposium. These are fantastic events. They're one-day events, and they bring together folks from all over the country to hear from experts, to work through some challenging workshops, to even take personal assessments, and then also just to mingle with folks who have common experiences, maybe dealing with similar challenges, and really kind of build that professional network that is ours. The information is on our website, but if you register now, you will be assured a seat. We do have an early bird registration, and that will be ending on March 1st. So with that being said, thank you all for joining us. Thank you, Laura. Thank you, Mike. Thank you, Alan, for bringing this crew together and making this happen. We are so grateful.
Thank you, Susan. It's a pleasure being here.
Thank you for having us.